The president of the Court of Appeal has acknowledged that the case of Raymond Morgan highlights systemic weaknesses in the justice system that he hopes will not be repeated. But the attorneys representing Mr. Morgan and others with similar cases intend to challenge the constitutionality of some of these laws. Giovanni Dennis has the story.
February 12, 2011, a seminal day in recent legal history. It's the day Raymond Morgan filed an appeal against his conviction. This, the president of the appeal court says, caused the matters to take, quote, a turn that is hoped will not be repeated in this jurisdiction. That because the appeal was filed incorrectly in the appeal court. The appeal court took a year to act on it, and further, there has been absolute silence from the parish court since that time. The appeals of hundreds of other inmates without lawyers are also lagging, a concern for attorney Terrence Williams.
And we wanted to see if we could see if there could be a proper legal solution, and as well as a legal solution, a proper the matter could be brought to the attention of the executive, because it is also a resource problem to ensure that transcripts can be prepared quickly and persons can have their appeals heard in time.
Hundreds of appellants are still in prison because under Jamaican law, your sentence stops the moment you file an appeal.
And for everyone who has to wait on transcripts to be done, if you think about it, if these people are waiting 6 to 10 years for a transcript to be done, it is a state of affairs which is unacceptable.
And so, in short, there are two weaknesses that Terrence Williams and John Clark want fixed.
What is the appropriate remedy when somebody's appeal has been delayed for long periods and they have been in custody for that time because of the failings of the state? That's one issue. The second issue is it fair and constitutional to say that your sentence doesn't start to run if you appeal?
Giovanni Dennis, TVJ News.